Good afternoon. This is the second technical session. This session will be moderated by Mr. Christopher Lau, Senior Counsel and former Judicial Commissioner, Singapore. He is also a MCIA Council member. Mr. Nicholas Peacock, Partner and Head India Arbitration Group, Herbert Smith Freehills, London. Nick is also a part of MCIA Council. The speakers for the session are Datuk Professor Sundra Rajoo, Director of Asian International Arbitration Center. He is also the past worldwide President of Chartered Institute of Arbitrators. Mr. Salim Mollan, Queen's Counsel, Essex Chambers. Salim is the former chairman of Untitled Chapter and of its arbitration group. Mr. Rajneesh Jaswal, General Counsel and Chief Legal Officer, NestAway Technologies Private Limited. Mr. Andrew Pullen, Barrister, Fountain Court Chambers. And finally, Manish Aggarwal, Senior Associate, 3 Crowns LLP, London. Manish has previously served as a member of IBA Subcommittee on Investment Treaty Arbitration. Thank you. Over to Christopher Lau and Nicholas Peacock. Thank you.
Thank you. Good afternoon. Perhaps I should add to what has been said about our speakers, what you may not know about them. And in alphabetical order, starting with Manish Aggarwal. Manish is dual qualified. He's an English solicitor as well as an advocate in India. And he has vast experience of complex, high-value, commercial, and investment treaty arbitrations. Rajneesh Jaswal is the General Counsel and Chief Legal Officer of NestAway Technologies Private Limited, a major user of arbitration services in India, with a run rate, I'm told, of 30 new disputes per month. As for Salim Mollan, what's not known is that he has a first in mathematics from École Polytechnique in Paris, and a double first in law from Cambridge University, and he's also licensed to practice before the Singapore International Commercial Court. As for Andrew Pullen, he is also based in Singapore, and he is also licensed to practice before the Singapore International Commercial Court. Lastly, for Professor Sundra Rajoo, as you'll see from his biography, he is a prolific writer on many arbitration publications on international arbitration. Thank you.
Wonderful. Thank you, Christopher. Welcome all of you. And firstly, congratulations to the MCIA for putting on another splendid conference. Delighted to be back supporting this wonderful initiative, and particularly pleased to be here in Delhi, bringing the message, not just a Mumbai institution, here for all users across India and beyond. So look, this session is all about costs of international arbitration, the myth that institutional arbitration is somehow so expensive, and that's why people are not using it, or they have that in mind. So pretty much all the topics we're going to look at on this panel will be seen through that lens of costs. We're going to try and deconstruct the myth and hopefully demolish it. So we're going to start by looking at the situation outside of India. We've got a broad range of experience on the panel, so we'll try and take experience of some of that comparative viewpoints. So we're going to start with the question to Manish. I'm going to look at outside of India. What factors do you consider influence the choice between ad hoc arbitration and institutional arbitration? And is cost one of those factors? And I have in mind in particular, London, where I am based, has a very big ad hoc arbitration market. Also, a very active institutional arbitration market. So how do they coexist? Hong Kong is another example of a very effective arbitration jurisdiction with a very active ad hoc arbitration sector. So Manish, what factors do you think influence the choice between ad hoc and institutional arbitration outside the Indian context?
Thanks, can everyone hear me? Great. Thanks, Christopher, for a very kind introduction, and thank you for your question.
In fact, before I look at the specific factors that drive the choice between ad hoc and institutional arbitration outside India, let me make some general observations just to place this whole debate in context. The first point is that if the parties remain silent about the mode of arbitration, so if they have not expressly or implicitly chosen institutional arbitration, the default is ad hoc arbitration. So if you don't choose institutional, you end up with ad hoc arbitration. The second factor I wanted to highlight, the general observation, by way of general observation, and since I've been asked to provide a perspective from outside India based on my experience as an arbitration practitioner in London for the last decade, as Nick said, of course, London is a big market for ad hoc work, but I think if one looks at major arbitration jurisdictions and if one looks at major international transactions, I think it's fair to say that institutional arbitration is a norm. So, in my experience advising transactional colleagues in law firms, at the time of drafting of an arbitration clause, you pretty much start with an assumption that it is going to be an institutional arbitration, and then the focus more is on deciding which institution to go with and what should be the seat of arbitration. I should mention that there is one exception, particularly when one is dealing with contracts involving states and state entities. In that case, you often find that states may not necessarily be amenable to arbitrating under the rules of a particular institution, rightly or wrongly, for various reasons. And in that scenario, it is common to choose a set of rules that have been devised specifically for ad hoc arbitrations, UNCITRAL arbitration rules. And of course, Salim is better placed than anyone in the world to talk about that. But again, in terms of the practice, in dealing with those kind of ad hoc cases, again, what you find is that at the stage of drafting of an arbitration clause, you often provide for an appointing authority, and in some cases also for an institution to administer the arbitration. So again, perspective outside India, if one is looking at major transactions, even in the ad hoc context, one is trying to build in as many features of institutional arbitration as possible. So against that background, I wanted to focus specifically on the question that Nick asked. What are the factors that kind of drive this choice of institutional arbitration vis-a-vis ad hoc? And again, I would like to focus on 4 factors. The first, and in my view, the most important factor, is the role that the institutions play as appointing authorities, both in relation to appointment of arbitrators, where the parties themselves have not appointed an arbitrator, or where the chair cannot be agreed, and B, also in relation to challenges to arbitrators. Now, in the ad hoc context, what one is often relying on is cooperation between the parties once a dispute has arisen. Or alternatively, if there is no such agreement, you're then kind of relying on the default rules that are provided for in the national arbitration legislation, in most cases, the law of the seat. But what happens where, let's say, for example, where one party refuses to appoint an arbitrator or challenges an arbitrator? Now, in the ad hoc context, the only recourse you will then have is to apply to the state courts at the seat of arbitration. But let's make the situation more complicated. Let's imagine an ad hoc scenario where the parties have not specified the seat of arbitration. There, depending upon the attitude of the national courts, the situation can get even more complicated. You contrast that with institutional rules, and what you would find is that most institutional rules will provide for the institution to act as the appointing authority, in relation to appointment of arbitrators, and even in relation to challenges. For example, in the English context, English courts will not entertain a challenge to an arbitrator unless the institutional mechanisms have been exhausted. Similarly, as for the choice of the seat of arbitration, if the parties have not made that choice, then most institutional rules will either leave it to the institution itself, that's the case in the context of ICC rules, or to the tribunal to determine the seat. The second factor I wanted to highlight was one about fees. Now, in the ad hoc context, it's often left to the parties to agree upon fees with the arbitrators. But again, in my practice, it can be a very awkward conversation for you to have with the decision makers. And that is why I think institutions can play an important role, where you have institutions, rules kind of provide for a specific method for calculating fees, and also they can act as intermediaries between the parties and the arbitrators when it comes to determination of fee. The third factor goes to enforceability. There's a softer element to it. There's a perception that an arbitral institution with a reputation can lend its cachet to an award that is rendered, and that can promote voluntary compliance or its subsequent enforcement. But I think there's also a legal element to enforceability, and that becomes more pertinent in the context of investor-state arbitration. I know India is not a party to exit, so this issue doesn't necessarily arise in the Indian context, but at least outside of India, particularly if one looks at the European context, the choice between ad hoc arbitration under UNCITRAL rules or choice of ICSID convention and ICSID rules to govern your arbitration can be quite critical. I can give you an example. I'm currently involved in a number of cases against Spain under the Energy Charter Treaty that gives you an option of choosing either UNCITRAL or many of the arbitration options, including ICSID. And there's been a lot of controversy, as you would know, following the ECJ decision in ACMIA as to whether an EU investor can actually bring a claim against another EU member state. And if one looks at the recent jurisprudence, including a very recent arbitral award, some tribunals have said that that judgment is inapplicable in the context of an ICSID arbitration. So again, in that context, you can see how the choice of an institution and the rules that come with that could be quite important in the context of the arbitration.
Okay, thank you. Let's bring it back to the realm of commercial arbitration. You made an interesting point there, Manish, and I want to get Sundra's views on this, about whether the prevalence of state parties and state-related parties in a market in fact inhibits the use of institutional arbitration, and whether there's a difficulty with states accepting institutions rather than ad hoc arbitration. Sundra?
Thank you, Nicholas. The first point, I think, when it comes to that, is that state parties will always try to look for an institution that exists in its own country. So if you have a developed institution or institutions that are service providers for arbitration, they will try to actually use that. And I can tell you in Malaysia, for example, state-owned enterprises like Petronas, the power utility plant like TNB, we also have a number of plants that are, a number of enterprises like water and all these things. They actually prefer to use institutional arbitration because they find ad hoc arbitrations difficult to control. I think that's one thing is that ad hoc arbitrations, while they may have it, they tend to rather have it under the rules because they know there is going to be a fee structure that's clear. They also know what are the timelines that they're going to come up with. And then I think more importantly, they have a little bit of control over the choice of the arbitrator because it's quite clear how it's going to be done. So I think that, but strangely, government themselves tend not to use institutions. In fact, I think that's one of the things I've complained in Malaysia, that government itself will say, we will use the facilities of the center, but will not put the center itself in the arbitration clause. So I think the real move that is going on in many jurisdictions, particularly that are developing, and I've seen that actually in Maharashtra, for example, with the Mumbai International Arbitration Center, where they actually go to the government and say, a contract beyond a certain amount, in certain value, you will have to use the institution. So I think that's the kind of, normally, and I understand, even in Indonesia, Bani is thinking of actually having a monopoly on arbitrations. I don't know how it's going to work, but they are doing that. And I think one thing you must be very clear, a lot of things are structural in nature. So if you start off with the premise that you only recognize institutional arbitration, for example, in China, no ad hoc arbitration is recognized as long as it is Chinese parties. That means domestic arbitrations, they do not recognize parties going outside and holding not under a Chinese institution or a recognized institution. So straight away, you will have an explosive growth in institutions in that country because they have to provide that service. So, but I think most of the other countries, like, like us, we have evolved in a different way. It starts off with arbitration being ad hoc, more friendly, more trying to get somebody as an informal thing. Then it becomes formalized through the acts, and eventually institutions come up, and institutions try to take that market share. I think that's the point I believe happens.
Okay, thank you. That's a very interesting comparative experience, and clearly in this jurisdiction we're dealing with an Indian homegrown institution, so hopefully the support from government should be there, and clearly in other markets we see that there's no obstacle for PSUs effectively to be adopting institutional arbitration. Let's move on to a slightly different topic. There are a number of factors there that have been raised that could affect the choice of institutional over ad hoc arbitration. What about perceptions? And again, I want to just take a view from Salim from outside India and from Rajneesh inside India about whether they believe that in the markets they have seen, outside India and inside India, that ad hoc arbitration is perceived to be cheaper and that institutional arbitration is perceived to be more expensive. Salim, is that a factor that you see, those perceptions?
Thanks very much, Nick. So, to be clear, we're going to turn in a moment to reality. So, as you say, we're dealing now with perception. Rajesh might correct me, but I think there's a clear difference of perception, probably historical, between where we have reached in jurisdictions such as London and most European jurisdictions and India. And what I mean by that is when I speak to Indian colleagues, you very often still have ad hoc arbitrations, and that tends to be the norm, whereas I would say that outside India, the general view is that institutional arbitration is less expensive. And why? Simply because it's more efficient. And you've heard Manish give a few examples, but in a word, oversight by an institution ensures efficiency. You don't lose time, for instance, where there is a default of appointment. You've all had stories of having to go to court simply because you've got a reluctant respondent in order to get an appointment. And that obviously will be lengthier than if your institution is appointing, or if your institutional rules allow for tribunal some default mechanism. You won't have to pay counsel to go to court, especially for that purpose, etc., etc. The same when arbitrator is being challenged, the same when arbitrator needs to be replaced for another reason, and one could go on and on. And what's interesting, if you look at it from the main set of ad hoc rules, which are obviously the UNCITRAL rules, is that there has been a tendency, as we have been reforming the rules over the years, and the main reform exercise, the main rehauling of the rules was the 2010 rules, for the rules to become institutionalized. And there was, in fact, a push at some point by a number of states and of other interveners within UNCITRAL for the PCA to be given a sort of default role, which would have made the UNCITRAL arbitration rules pretty close to institutional rules with the PCA at the center thereof. And that was resisted in the end precisely to keep the ad hoc nature of the rules. But other amendments that were introduced show clearly the trend of institutionalization. And one example is the new Article 41, which you will find in the 2010 rules. What does that do? That effectively creates a mechanism where none existed to allow an appointing authority, which will very often be the PCA, to deal with the awkward issue which Manish was just referring to. How do you deal with a tribunal who is going to be imposing fees which you deem too high? And what that does is it does it in two steps. First, at the outset of the arbitration, you may request the tribunal to say clearly how it's going to be billing you, hourly rate or some other arrangement, and that's reviewable by the appointing authority. And then at the end of the arbitration, you also have a mechanism which allows you to have a review of the overall fees by the appointing authority. So what do you see? That a mechanism which is ingrained in institutional arbitration is now being brought into ad hoc arbitration. And that really tells me, Nick, that the perception clearly has been that outside India, that institutional arbitration is more efficient and therefore less expensive.
Thank you. Right, Rajneesh, give us the perspective inside Indian corporates, inside the SME sector, inside legal. What's the perception about institutional arbitration?
Right. Thank you. And just to give some sort of context to why I'm on this table, I am probably uniquely qualified to answer this question. I head the legal department at a startup or an SME. We've been around for about 3.5 years. The company is called NestAway Technologies. We are in the rental space. We are in a space where there are disputes between landlords and tenants, where the values of the disputes may or may not amount to much, and they are frequent. NestAway today, and we've taken recovery of debt, as you want to call it, very, very seriously over the last 3 or 4 months. I have my teammates and colleagues in the crowd, and we filed about 115 arbitrations in the last 3 months. Arbitration, very proudly, is our stated policy to resolve our disputes between landlords and tenants, to recover our dues from other suppliers. If you were to go onto our website, you would find our arbitration clause. And as I said, we've done about we've started about 115 arbitrations in the last 3 months. Very, very low value, low ticket arbitrations. And we continue to do about 30 every month. And we will continue to do that because that's our business model and that's our stated policy of resolving disputes. Now, with that context, the question of is arbitration expensive? Being in-house for a number of years, I can tell you that is that an accusation or is that a question? Yes, it is expensive. Any form of dispute resolution is expensive today. But from our perspective, institutional arbitration is certainly cheaper. Though if you were to add up the value of all the 115 disputes we've started today, they would barely scrap the limit to enter in any one of the institutions. If I was to look at the entry value, for example, MCIA, and not beating on them, we would not even qualify to go to MCIA. But that being said, from a very, very high-level perspective, institutional arbitration makes sense. Institutional arbitration is, and a number of people have said that already, is very directed, is very fast. We know how much cost we're going to incur. We can budget them. We know where the arbitration is going. We have some form of guarantee that the arbitrators are going to be impartial, and so on and so forth. So expensive, yes. I would also urge you to sort of look at our website and what we've done over time. And again, full credit to my team. We've started our own version of institutional arbitration. We run arbitration we've taken some of the rules, we've brought it in-house. We are using a lot of innovative technologies in running arbitrations, and that's helping us drive down cost. So again, institutional arbitration is great, and we can talk about this later. But please do think about SMEs like us. NestAway is not the only SME out there which has a significant chunk of money to be recovered. Arbitration is an enabler of commerce. Don't forget us. Don't forget us in the big treaty disputes. Don't forget us in the big international arbitration disputes. There are a bunch of SMEs out there who do need the institutional arbitrations. Thank you.
Thank you very much, Rajneesh. Perhaps I could move on back to Salim. Salim, you spoke extensively on the perception, but could I ask you, in reality, since you've been involved in some very large, complex arbitrations internationally, which have you found is more expensive, institutional arbitration or ad hoc?
Thank you, Chris. In my view, perception from outside India in this field actually reflects reality, and that is that I have found in many cases that institutional arbitration has tended to be cheaper in terms of the overall arbitration costs, and I distinguish there the party costs, counsel costs, which obviously the institution or the tribunal will normally not have much control over. And it's very important, of course, to understand that. If you look at the overall cost of an arbitration, when you read the statistics telling you, for example, an investment arbitration normally will cost about $8 million in fees, the bulk of that are counsel fees. And then you will take the arbitrator's fees, and then if you have institutional arbitration, you will add on the institutional costs. And those are a fraction. And in my view, when you look at the figures, the extra cost of the institution is normally more than made up by the gains in efficiency, which I was referring to. You should also note the possibility of saved costs when you're using an institution. So, for example, if you are using the PCA not simply as appointing authority, but as the institution running your arbitration, you are going to benefit from the host country agreements of the PCA. As you know, Chris, then you've got free space potentially at Maxwell Chambers all over the place. You have similar arrangements with the ICT in Paris, and I believe, I don't know, I could be corrected, but the MCIA probably has the same sort of arrangements. If they don't, they should, because that's something which institutions can negotiate and have bargain rates, etc. So the overall reality, in my view, is aligned with the perception. I just wanted to take briefly this opportunity to address what Rajneesh has been saying, which is, what do you do when you have a multitude of low-value disputes? And more generally, I think we need to recognize that there need to be particular formulas for particular problems. And institutions like an institution like the MCIA, which is aiming to broadly serve the commercial arbitration market in India and is starting to do a wonderful job of it, is not going to be able, except if it develops specific regimes, to deal with that sort of problem. Because people will be coming to arbitration for many different reasons. Your starting point will be comparing to what? Comparing to what you will be facing in litigation. Now, we need to recognize also that if you're coming from a common law perspective of, say, England, where court litigation is unbelievably expensive, then arbitration, if you are a heavyweight commercial litigator, one might think, what's the fuss about? But what you pay for is, inverted commas, the quality of justice. You end up having week-long hearings with detailed review of evidence. On the other hand, if you come from France, it's unbelievably expensive because your hearing is quick and easy. Normally the judge won't have bothered to read the papers and knows the answer. But maybe the quality of justice is not the same. So what I mean to say is there are cursors, and one needs to find the right place somewhere. And when you hear people often say, oh, we should go back to the olden days where arbitration was quick and easy. Well, remember what arbitration was. You're talking about, for example, commodity arbitration. So somebody would go on the docks and say, no, this is not the cotton you ordered. Fantastic. I mean, how does that help us with the sort of problems we have? So if you're going to deal with massive, complex litigation, then that has a cost. One has to decide how much of a cost. Do you want a 1-week hearing? Do you want a 2-week hearing? Do you want a full common law style hearing? That is something which actually the parties have a degree of control over and which institutions can also help you with. And before surrendering the mic, just very briefly on the issue which you raised, Nick, about why do states opt for institutional arbitration when they really ought to, for ad hoc arbitration when really they should be opting for institutional. And I think it's more a coincidence than anything else. Many states will be happy using United Nations rules. And it so happens that the UNCITRAL rules are ad hoc rules. And I think that's driven a lot of what we've seen from a state view. I don't think there's any innate reluctance to go for institutional arbitration.
Thank you very much, Salim. Picking up on that then, perhaps I could ask Professor Rajoo, as the head of a major arbitral institution in Southeast Asia, what, in your view, are the factors that drive the costs of institutional arbitration, and to what extent can parties influence these costs?
Thank you, Christopher. I have to actually start off with what Salim has said. Costs, where the institution is concerned, is actually a minor part of the real cost. I think there is actually there are a number of factors that drive up costs. I think first is that the parties' conduct in how they actually want to complete the arbitration. And sometimes there will be excessive submissions to make sure this is what I call the due process paranoia that they have. And then the third thing is that they sometimes don't cooperate and they try to block, and there's a lot of churning of paper. There's a lot of churning of paper, and every paper that is churned, there is a billable hour that comes. So I think, that is one thing that is outside the control of the institutions per se. So when you choose an institutional arbitration, then the rules kick in. And when the rules kick in, you will find that there are basically a few ways that is done. And most institutions have that. One, they will say there is a choice of an expedited procedure. That could be inbuilt in the rules itself, or you choose a specific set of rules, but it could be based on the amount that is involved. I'm in Hong Kong, I'm doing one where it is actually not based on the amount that is involved, it is a documents-only arbitration for the full matter, which must be finished in 6 months. So I think the institutions normally provide that kind of choice, and that kind of choice actually cuts back on the cost. So if you decide very early, you may decide to choose, let's say, fast-track rules, or you are quite aware there is an expedited procedure within 6 months, you select that. But normally, when that comes to a dispute, one of the parties will always have a change of mind. They want to be heard totally. They say 6 months is not enough to be done, and there will be objections coming up. There will be procedural, interlocutory arguments saying, I need more time, this is not what I agree. Normally, the first point will be the institution. The institution will actually decide that it has to be under this procedure. Then it will go to the arbitral tribunal after it's constituted, and the same question will be put to the arbitral tribunal. And the arbitral tribunal will again decide, because it will say, I'm bound by the rules, and this is what you have agreed to. That, I think, is very, very useful. I think like for SIAC and certain institutions, the expedited procedure is based on the disputed amount, which is, let's say, less than 6 million Sing dollars. The chairman can decide to speed it up by using the expedited procedure, and it will be a sole arbitrator. Again, that will save costs. I think that those are the quite clear things. The other thing is that normally, with the timelines that are set by both the Act and the institutions, you will have to actually finish the arbitration within a prescribed time. And that is a wonderful device to save costs. One way or another, people will have to finish it. They cannot drag it on. The decision has to come out. The award has to come out within, let's say in India, 1 year plus 6 months maximum. So you will find that suddenly domestic arbitration is transformed. There's a different way of doing things. But that used to actually happen in institutional arbitration because, for example, most institutional arbitrations will say that you need to produce the award within a prescribed time from the close of submissions. I think that is always there. The other way that actually that you reduce costs, particularly institutional arbitrations, is what Salim talked about. Let's say if you pick the PCA, they will have these host country agreements. And the best part of the host country agreement, if you do it under the PCA, the venue is actually free. The venue is always free because, we all signed these agreements because we want PCA to come. We have to provide the venue free. I think a lot of people don't know that. The second thing is that, of course, you have to also choose the venue where it is cost effective. The other thing about the downside of institutional arbitrations, particularly I found in Africa, I've done a couple of arbitrations in Africa, they pay so badly to arbitrators, the arbitrators don't want to spend the time. I think that is also a great help because if you are going to be paid an amount that is actually very, very low, your charge time is this amount, you are making a loss. One way or another, you will actually conclude the matter. So you will not drag the matter. Whatever due process or whatever it is, you just follow the rules and you will get the decision out. So I think these are the things where institutional arbitration really help. Thank you.
Thanks very much, Sundra. Picking up on what you said about one of the factors, such as, for instance, a sole arbitrator, as one way in which costs could be saved. Andrew, perhaps could I ask you, with your wealth of experience in advising multinationals in very complex arbitrations in both Asia and in Europe, how often do you consider, in your experience, has this been a factor in choosing a tribunal, whether it's a one-person, or a sole arbitrator, or a three-person tribunal?
Thanks, Chris. I think it's certainly fair to say that as a general rule, if you have a three-member tribunal, your arbitration costs are likely to be somewhat higher than if you have a sole arbitrator. I don't think that's for two reasons. One is that it makes sense that you have two additional arbitrators to pay, so it will have an impact on the fees of the arbitrators themselves. And if you look at the fee calculators that are available on the websites of many of the arbitral institutions, you can have a look at that and see what the differential is. And in preparation for this, I did that, and you can see that it comes out approximately 40% of the cost of a panel of three if you have a sole arbitrator, based on the fee calculators, and that is taken across a number of different institutions, covering both arbitrator fees and the institution's administrative fees. But of course, I mean, the significance of that difference diminishes the larger the value of the dispute. And I'll come back to that in a second. I think the second way in which having a sole arbitrator can save costs is the point that Sundra mentioned a moment ago, that the longer the arbitration goes on, the more time the parties and their lawyers and their expert witnesses, etc., will spend on the procedure itself. So I think it's absolutely fair to say that a sole arbitrator can save some money. But then two further questions come out of that, it seems to me. One is, does that really impact on your choice of institution versus ad hoc arbitration? Because you can choose the sole arbitrator or a panel of three arbitrators in either situation. You can put that into your arbitration clause for an ad hoc arbitration or for an institutional arbitration. So I think that's the first question I would ask, and I think it has limited impact on that choice. But I think one area where it could make a choice is if you have it could make a difference is if you have a contract which you can see could give rise to very small disputes, where the cost differential will be more important, but it could also give rise to some very large disputes where it's not so important, and where, as I'll come on into them in a moment, the advantages of a three-member tribunal may be important. You do then have potentially the flexibility of expedited procedures in certain rules, which will allow you to distinguish and to have a position where the low-value disputes are likely to be heard by a sole arbitrator on an expedited procedure, but larger value disputes before a three-member tribunal. And the other potential option to you then in that situation is that you could leave the number of arbitrators up to the decision of the institution itself, which is the default in many rules if the arbitration clause doesn't specify the number of arbitrators, and they can then take into account the size of the dispute in selecting how large your tribunal should be. So I think that's the first subsidiary question. The second subsidiary question is it worth having three arbitrators? And I think in many cases it will, and particularly in cases which are of sufficient value. And I think this is where, as parties considering drafting your arbitration clause, you do have to think very carefully, because as has already been mentioned, the fees of the institution, but also the fees of the arbitrators, are a relatively small proportion of the overall costs of an arbitration that goes the distance. You'll spend far more on the lawyers' fees fighting it, and even the impact of having three members of the tribunal and the additional time that it will often take. It may still be worth it, and often will be worth it, if you've got a dispute that is worth sufficient either in terms of monetary value or in terms of importance to your business, that you have the added comfort of three arbitrators hearing your arbitration. That reduces the risk of what might be termed a rogue decision, an arbitrator having an off day, an arbitrator not fully understanding what the issues were in the case, and that is important in the context of a system where there is no appeal on the merits, and certainly is not supposed to be any appeal on the merits. So I think 3 members is often going to be the right decision. And I think coming back to the point that Christopher asked in the first place, how often do parties think about this? I think well-advised parties will think quite carefully about what to put in their arbitration clause at the outset and how many arbitrators to put in, and they will take into account those sorts of issues. In practice, it doesn't always happen that way. Parties do sometimes put clauses in without necessarily thinking it through. But I think if they're well advised, they will give it some careful thought.
Wonderful, thank you, Andy. Now, so whether we have 1 arbitrator or 3 arbitrators, clearly we as parties are also, to a large extent, dependent on the grip that is asserted on those proceedings by the sole arbitrator or the chair. So my next question to Manish is going to be, to what extent and what role does the chairman of a tribunal, or indeed a sole arbitrator, have in controlling the costs? And of course, as an institution like the MCIA, this is not a theoretical question that we ask just for the enjoyment of it. When the MCIA is asked to make appointments, and obviously had a couple of Section 11 appointments to make already, one of the things that you will be glad to hear your institution grapples with and spends time thinking about is the sort of individual and the sort of conduct that a sole arbitrator or chair will exert on those proceedings, and whether that will be consistent with the way the institution wants those proceedings to be run and the way we think parties want them to be run, in order to enhance the institution's reputation and the desire of parties to come back to it. So, role of the chair, Manish, what can be done?
Thanks, Nick. So I think the short answer to the question as to whether the chair has a role in controlling the cost of arbitration is an overwhelming yes. In fact, in the US, there's a saying that I don't want to know what the law is, I want to know who the judge is. And I think in the arbitration context, one could take it further and ask the question, who the chair is, such as the pivotal role that the chair plays in an arbitration. And it is a chair who typically writes the awards. It's a chair who typically coordinates deliberations with the co-arbitrators. And it's the chair who will generally set the tone and pace of the case through draft procedural orders and procedural decisions. And I think in that context, the answer is yes, a chair has, a very important role in controlling the cost. Now, let me give you a few examples, and I think that role actually permeates the entire process of arbitration. And it can make a real difference whether you have a proactive, industrious, and experienced chair. For example, at the very outset of the arbitration, when the question arises as to what kind of procedure should be adopted for the case at hand, it is important that you have an experienced chair who's not simply going to dole out a standardized template without necessarily looking at the specifics of the case. And again, they're having a chair who's experienced and who can come up with a procedural schedule and procedural rules that are tailored to the specifics of the dispute in question can play a huge role. Similarly, with the written submissions. Now, if you look at the current process in arbitration, we're actually drowning with the burden of written submissions. You have multiple written submissions before the hearing, multiple written submissions after the hearing. And again, I think even in the 2018 survey, there's been a demand from the users that chairs take the lead in controlling not only the number of submissions that are filed, but also impose page limits on written submissions, something that's being done in the context of post-hearing briefs, but one can see that being applied more generally. The IT sophistication of a chair can play a huge role. I think gone are the days when one sits in a hearing with leverage files, with thumb numbing exercises of having to turn pages. A chair can play a significant role in promoting an e-hearing, and that's where the IT sophistication can play a role. I think one factor that has been pointed, I think over the last few years, is the role of the chair in guarding against what has been called due process paranoia. There's, I think, a growing concern that most tribunals do not take bold steps because of a concern about due process, because of the concern about their awards being set aside. And again, I think there, the chair, in collaboration with the co-arbitrators, can play a significant role in ensuring that the procedure that has been adopted for the arbitration is followed. So I think in terms of the role of the chair, that's quite important. Now, in practice, and again, there may be a difference of view on that, how significant a factor is this in the choice of the chair? I think, as Nick said, when institutions are making the appointments, this can be quite a useful and quite an important factor. But I think at the stage where one is talking about appointments of chairs by the party-appointed arbitrators or by agreement between the parties, I think it can be a soft factor because, obviously there's a general procedural expectation that any chair will be experienced, will be available, and will be procedurally savvy, somebody who's able to run a tight ship. But in the commercial arbitration context in particular, you don't have a lot of published awards. So it's sometimes difficult to have a clear view on how a particular candidate is going to run an arbitration. And that's where, you rely a lot on your institutional know-how, your personal experience of different candidates. But I think that's where, there has been a great call for transparency in terms of procedural decision-making and an arbitral candidate's case management skills.
Thank you very much, Manish, which really brings us to what an arbitral institution can do to control the cost of an arbitration. Sundra?
Thank you again, Christopher. An institution has actually 3 roles to play in controlling costs. And let's say we look at it chronologically first. First thing is when somebody decides to commence an arbitration, the institution becomes actually very crucial compared to ad hoc. Is that even in ad hoc, there are situations where many legislation provides for the institution to be the default appointing authority. So the institution itself, whether it's ad hoc or in that situation or institutional, has a very important role to play in commencing the arbitration, in selecting the right arbitrator. And selecting the right arbitrator is actually quite important for actually controlling costs. Because if you have a skilled arbitrator, it will basically suggest the person will have a grip on the proceedings. He will manage the proceedings, or the tribunal will manage the proceedings well, particularly if it is parties are completely in opposition, and it goes on. The next thing that you won't get in ad hoc, you find that most of the legislation say you must submit a statement of claim, you must submit a statement of defense and reply and all these things. But it doesn't set any timelines. But you will find in many institutional rules, there will be timelines set in. And the fact that the institution is administering the arbitration will ensure that the tribunal itself is very cognizant of the fact that it has to stick to deadlines, and when it doesn't want to give reasons, of course, when parties both agree, perhaps they will give it, but when parties don't agree, they may actually stop that. The third thing is sometimes we find this happening. Institutions actually collect fees on behalf of the arbitral tribunal and also for themselves. And sometimes the collection of the fee process takes a long time. You will find that, and I think most of us know, that some parties will be quite reluctant to pay, and you have to decide at that point of time whether you want to commence an arbitration. There are policy reasons. Some institutions will not start if you don't pay the fees. Or some institutions like mine will start when we get partial payment of the fees. So basically, again, that's how the cost is controlled. And the other thing is that, let's say, the institution will watch the arbitration proceedings going on, and then looking at the proceedings, let's say there is non-movement. Everything comes to a halt. The institution may step in and say, would you like to terminate? If the fees are not paid, would you like to suspend? So in that way, the cost of the arbitral tribunal is cut back So I think, basically, then you're able to pay whatever you have and then cap it there. The last item is actually enforcement. And this is where we really have an issue. We have fantastic tribunals, but they write bad awards sometimes. So institutions can see that, And that's where scrutiny comes in. We have introduced technical review and all these things because the real cost is after the award comes out, when you go to the court. And if it is a bad award, then the money keeps on multiplying. So in fact, I always count the cost of an arbitration is until the money is paid out or the award is satisfied. That is the actual cost from commencement until the end. That is the end. It is not the end when the award comes out. Thank you.
Thank you. And that's a good message, I think, for users of arbitration. Now, we've got a few minutes to wrap up. I'm going to come to the floor for questions in a second, but I do want to give the last word to our user on the panel, to Rajneesh. We've been talking about costs. You've told us a little bit about your body of disputes. Tell us, what can we do better? We, your institution, are here to serve you. What can we do better, especially around cost structures for institutional arbitration?
That's right. I think, and as I've said earlier, I'm a user of arbitration services. I'm a consumer of arbitration services. And from that perspective, when we start to look at arbitrations, you start to question every line item which goes into the arbitration cost. I am a retail user. I am doing about 100 arbitrations a month, and I am going to, as a retail consumer, look at the cost of notices, the cost of the IT involved in the arbitration, the time it takes, and each one is a cost for us. So at least at NestAway, we try to bring down the cost of each one of those. And rather than talk about the very specific measures, I would like to sort of take over from where Manish said. Consider the paranoia of not following due process. This paranoia that we are not going to follow due process because you're going to use IT, because you're going to have a sole arbitrator who is going to prescribe a no documents arbitration, or whether you're going to put page limits on the submissions that are made, on the number of times that you can appear for the arbitrator. All of that sort of tends itself to the paranoia of not following due process. So as and when arbitral institutions look at, institutional arbitrators look at driving cost, try to counter the paranoia of not following due process. Try to take bold steps. Start using emails as a form of serving of notices. At least in India, it's not very prevalent. I know that at NestAway we do that, and we are using IT to do that. We're trying to file our claims through emails. It will work, it will not work, but probably, use technology. Reduce the number of pages you can use to submit your submissions. Do you even need lawyers to be part of the arbitration process? And I know it's a question which is very far out, but under the law today, anybody could be an arbitrator if you could, at least in my view. You can run a computer, you can speak English, you have reasonable sense of fairness and justice. Then why do I need to have a lawyer who's probably more expensive? It ties down to the question of recovering costs by the arbitral tribunal itself. So the view from my side as a retail consumer would be question the paranoia of not following due process. Question some of the long established norms we have around the justice delivery process and cut costs down there. Yeah.
Okay, thank you. Actually, I'm going to give one last word, because we did have one other topic that I just want to pick up on briefly, and that's the question of third-party funders and where they sit in this process of controlling costs of arbitration and whether they might actually have a role to play. Andy, from the London market where third-party funders are increasingly active, what do you think?
Well, I think the third-party funders are not only active in London, but I mean also now in Asia in quite a big way. And we've seen that with the legislation in Singapore. We've seen it in legislation in Hong Kong, although that's not yet in force. And I think as time goes on, we're going to see it more and more. And it was already discussed this morning, the question of legality here in India. In terms of the impact on costs, I think there's probably a couple of points. One is that you have sophisticated users of arbitration in the form of the third-party funders. They are bearing the costs, they are investing the amounts of costs, and so they will be interested to ensure that the arbitrations are run efficiently. It is going to be a factor for them, I think, as part of their investment decisions in terms of what cases to take on, to look at the question of whether they think the arbitration is going to be run in an efficient manner, as well as the other factors, the underlying merits of the case, the ability to enforce the award against the ultimate, against the party on the other side if they are ultimately successful. And so I think that there may be an indirect effect on parties and their choice of arbitral mechanisms, whether and a move towards institutional, on the basis that that will be seen as a positive factor for getting a third-party funder to invest in your case if you can show that you're going to have an efficient procedure.
Well, thank you very much, Andrew. We would have liked to take questions from the audience, but I'm afraid we've run out of time. But we're all available to take questions offline. And on that note, can I thank all the speakers for their very helpful and insightful contributions this morning. Thank you.